Well, hi there, everybody, and welcome. Thank you so much. I'm just busting a gut because I just definitely want to tell you what's going on. It's very, very exciting for me, and very, very exciting, I think, for all of us as real estate agents in the state of California. So to start off, my name is Kevin Burke. I believe in education. I believe it's very, very important because I've always said that I'd rather teach you risk management than have to handle damage control. So there's my telephone number. There's my email address. Coffee with Kevin every Wednesday evening at 4:30. Try to make it. It's excellent. I have not been charging for it, but that is going to change. We are going to start charging for that. I've got way too many people showing up, and it's a lot of really smart questions, or really a lot of really smart answers. So there's your link, bit.ly/ coffee with a K with Kevin, and the uppercase is intentional. Okay. All right. So I have some credentials that make me, I believe, qualified to talk about what it is I'm going to talk about. Certainly 45 years in the real estate business, right? And then I am just chair and vice chair of everything. I just live to serve, and I've just been asked to be on the attorney roundtable for the Northern Virginia Association of Realtors. And I'm very excited about that, as well as their professional standards committee. So it just keeps going on and on. I'm here to serve. I want you to be okay. It's very, very important. Okay, so we're going to be talking about things that are going to appear to be legal. I am not a practicing attorney. My trial work is limited to testifying as an expert witness. Standard of care is my specialty. Did the agent do what they were supposed to do? Agents' duties of inspection and disclosure, and finally, market conditions, at least in San Diego County, right? So our conversation today is not intended to be a substitute for the advice of your broker, nor for that of your attorney. Please consult with them as appropriate. Okay. All right. Thank you for joining us. We're going to talk about the November 2024. This just happened just a month ago. We got a pre-release on some issues, and I want to go over those with you. New and revised C.A.R. forms. Okay. And again, it is the pre-release, and I just want to throw a caveat in there. Please do not use these forms in any of your transactions. Please do not use the language in these forms in any of your transactions. Okay. And I always find, why do I even have to say that? Because people go, wow, that's really cool. I'm going to use that. I'm going to use that. Remember that if you are doing something other than using the standard form, you are operating outside of your wheelhouse, and that's going to be considered legal advice. The Department of Real Estate, by virtue of your real estate license, allows you to explain the standard form. But when you're creating your own form, you are outside of that. Okay. So please review my webinar on how to create DRE compliant templates. And that's going to be, I'm going to give you the link for that later. It's on our YouTube channel. All right. And cue up the QR code reader. So here you go. Click on the, hit your QR code. You've got it. That way you can get to that right away. Always double check the revision dates at the top and the bottom of the forms. Everybody good with that? Okay, so let's go ahead. I'm going to launch into it here. And these are going to be in the PowerPoint version, so they're going to be pretty easy for us to take a look at. He says with confidence, right? Because now I'm looking at my screen. I don't see it. There's got it. Oh, show all windows. Here we go. 12 years of college. Okay, so where's the rest of my windows? There they are. Let's start off with my agency disclosure, clearly my favorite form, right? So this is California Civil Code 2079. So the California Association of Realtors learned a long time ago that rather than being, subject to whatever people were doing that weren't really in real estate, we decided to start taking control of that. And so now we have input into these forms. So notice the revision date, 12 of 24. You know that this is 11/24 right now where we are. So please don't use this form yet. But this had to happen, right? We had to update this. And as a result of the Assembly Bill 2992, which the governor has already signed into law. Admittedly, I've got to help get that fixed because there were some things that were done in a hurry, and my hat is off to the committees at C.A.R. because the people that are doing these things are just brilliant, and so I'm just the lucky guy that is asked to add Smith this. So this includes a buyer's agent under a buyer broker representation agreement with the buyer. Okay, all right. Remember again, as C.A.R. we have a standard form for that. You should be using the standard form. Okay. All right. So we've added that language in there under the buyer's agent part of things. And then down here, we see another addition. The above duties of the agent in a real estate transaction do not relieve a seller buyer from the responsibility to protect their own interests. Okay, that was missing from previously, so not a substantive change other than now it makes more sense grammatically. And then when I get into page two, and page two is the part that just seems to me that nobody ever reads, I think it makes really good reading. Buyer broker representation agreement means a written contract between a buyer of real property, and a buyer's agent by which the buyer's agent has been authorized by the buyer to provide services set forth in subdivision A of section 10131 of the B&P code for or on behalf of the buyer for which a real estate license is required pursuant to the terms of the contract. And oh, by the way, and the DRE regulation, right? Okay. So, and again, DRE looks at the B&P code. Trust me on this. Okay. So, and then give this. Now, this is the part we're going to have to change. So, the seller's agent, if any, shall provide the disclosure form to the seller prior to entering the listing agreement. B, the buyer's agent shall provide the disclosure form to the buyer as soon as practicable before execution of a buyer broker representation agreement and execution of the buyer's offer to purchase. Now, what's going to happen in AB 2992 is we're going to change the language to where you have to actually have a buyer representation agreement prior to showing a property to the buyer, whether physically or virtually. And so the reason that that's important is that's going to change some of the language here. We're going to have to give the agency disclosure to the buyer before they do the buyer representation agreement, and that buyer representation agreement is going to have to be prior to showing them the property, again, whether virtually or physically. Okay, and again, watch my YouTube video. I've broken the buyer representation agreement down paragraph by paragraph. It just, I don't know. I'm a broker practitioner just like you, so I want to make sure that you're okay. So that's my agency disclosure form. So some minor changes. Let's take a look at my listing agreement. So here is the listing agreement. Let me double check, make sure you can see it. Yes, you can. Okay, good. So here it is again. Revision date is going to be 12/24, and again, this is 11/24. So this is what it's going to look like. A couple minor changes. So here we are in 2C1. See attached broker created compensation schedule, and also the same language in 2C2. Everybody good with that? Okay, in 2E2, it says seller willingness to consider concessions. If permitted by the MLS above, seller authorizes broker to put in the MLS that seller is willing to consider offers asking for concessions, and no amount of the possible concession will be stated in the MLS unless the seller notifies the broker in writing of the amount. Now, remember again, this is the agreement between the seller and the seller's agent. So now we're making it very clear that we are not allowed to be putting concession amounts into the MLS. That's going to be one of those things that's either going to take a written request by the buyer at the time of the offer, perhaps, or even a telephone call between the agents, that kind of thing. But we're not going to put anything into the multiple listing service or anything directly linked to the multiple listing service. Okay, everybody good? So far, so good. Okay, so that's a big change. Then we have some paragraph changes to change numbers here as well. So again, my hat is off to the attorneys at the California Association of Realtors because they got all this figured out, right? All right, so then let's see, any other changes in here? I think we go quite some time before we get to another change. Okay, here we go. Paragraph number 10, seller concession. So now we're going to define what those concessions are. Monetary payments that a seller agrees to contribute towards a buyer's expenses and other costs a buyer is responsible for in the transaction. Okay, pretty easily said. So it doesn't say compensation, it says concessions. Remember, we got rid of the word commissions completely. This has to do with a buyer's request to have the seller pay some of the buyer's expenses. Okay, so concessions may include, but not limited to, again, here's my list, inspections and buyer broker compensation. Okay, concessions specified in the MLS must be allowed to be used for any permissible buyer expense or cost. Okay, so again, remember my lender credits versus my contractual credits, and must not specify the concessions are to be used for broker compensation. Okay, so a term in the buyer's offer may specify the seller agrees to pay all or a portion of the compensation that the buyer owes its broker. Okay, so again, remember the seller has no obligation at law to pay for the buyer's broker's compensation, right? For one thing, and secondly, the seller doesn't. If the seller does agree to pay for the buyer broker's compensation, they don't have to pay for all of it. Okay, so just so we're aware, concessions identified in an MLS listing are not promises to pay, but instead indicate to a buyer that the seller will consider offers asking for concessions. So in other words, just send us an offer, send us what you want us to look at, and we'll decide what we're going to do from there. So concessions specified in the MLS are not intended to be binding binding on the seller, okay, unless included in the accepted purchase agreement. Everybody good with that? Okay, those are some of your really big changes. Okay, so moving forward here, we're going to go down. I think that's everybody on that one. Let's take a look at my RPA really quick. So here's my residential purchase agreement. Again, note the 12/24 date. And again, I've probably said it 3 times now. Please do not use this form until we have launched it officially. So seller's payment to cover buyer's expenses and costs. So you're going to see this is very similar to what we had before. So seller's credit to buyer for closing costs. And then 2G2, seller additional concessions. And again, this is going to be that language that's going to kind of look like the listing agreement. G2 does not include buyer broker compensation. G3, though, consistent with the current RPA, is going to talk about seller's payment for buyer's obligation to compensate the buyer's broker. Okay, so it talks in here, seller agrees to pay, if anything. Now we've done, essentially, we've taken that seller payment of buyer broker compensation, the SPBB form, and then we put that language inside of the purchase agreement. Okay, so this is a rewind back. I remember back in 91 when we actually put the commissions in the purchase agreement, and then we were always hiding it from the buyer because we wouldn't want to put in how much the seller was going to pay us. We would put in an amount after the buyer signed the contract, which of course for me makes me crazy, right? Because it's like, well, what are you doing altering a document above a signature? It just never made sense to me. So here we go backwards, spin back to that time. Seller agrees to pay out of the transaction proceeds some percentage of the final price and a dollar amount, if any, or a dollar amount towards the obligation of the buyer to compensate their own broker. So again, upon request by the seller, the buyer shall deliver proof of that obligation, and that's usually going to be send over a copy of the buyer representation agreement. You got 10 days, you got 3 days to do that. Everybody good with that? Okay, makes sense. All right, we've just added the SPBB form to the contract, folks. Makes it pretty simple. Okay, so let's fly through here now. A lot of the changes here are just the date. And I think that's we've got another one coming up here in a second that's going to be a big deal. And as I flash through this as fast as there we go. Paragraph number 18, which is the same, which again, we have the current paragraph 18. This is the new paragraph 18. Timing of compensation, of course, is going to be upon close of escrow, right? Or default by the buyer through no fault, of the seller, those kinds of things. Seller's payment to compensate the buyer's broker. Seller agreement to pay all or a portion of it is subject to the following. The amount seller is obligated to pay shall be no more than that specified in the compensation agreement between the buyer and the buyer's broker. Remember, you may not receive compensation from any source more than the amount you have specified in your buyer representation agreement. Okay, seller shall be entitled to a copy of the portion of the written compensation agreement. So that's the buyer representation agreement. Buyer shall provide proof of that agreement within the time specified above in 3G3. And if the buyer does not provide proof, then the seller has no obligation to pay the buyer's broker. Whoopsies, that's not going to be a good thing, is it? So the amount of compensation, if it's a percentage, will be based on the final purchase price. So again, C.A.R. counsel, wing it. They're doing great, right? They just put all this stuff together. Delivery of the buyer representation agreement, again, upon request, so that's going to be such as the last page of the form BRBC, because remember, that's the page that has that little carve out that says, here's how much the commission is. And oh, by the way, the buyer has initialed that paragraph. And then notice the typo over here, C.A.R. should be C period dot C period, A period, R period. So I'll get them to fix that. Okay. So whether it's the BRBC or the PSRA, which is that, in the immortal words of Gov Hutchinson, that's the BRBC light. I know he's probably going to get in trouble for saying that, but I just thought it was hysterically funny. Third-party beneficiary, everybody agrees that the buyer's broker is a third-party beneficiary of this agreement, okay, of this purchase agreement, and may pursue the seller for failure to pay that amount. That's an important thing, isn't it? Okay. All right. Okay, that being said, let me see here. Where am I? Oops, got money flying everywhere. Okay, moving forward, and I think that is the most damage we're going to do. Yes, okay. Now I have broken this whole thing down into sections. So the next section that we're going to talk about, we're going to pull up the lease agreement. So we're going to talk about the lease agreement really quick. And on the lease agreement, there have been a couple of changes in that. Pretty much what you would expect. Now we're going to start talking about compensation that the tenant may be required to pay the tenant's agent. Now, remember, I've always said that I think you should be using that buyer representation agreement with a tenant before you show them property for whatever you want that amount to be. But you don't have a do you have a contractual relationship between yourself and your tenant? And so here under paragraph number 35C, housing provider and tenant agree to mediate disputes or claims involving the owner's agent broker, the tenant's agent broker, et cetera, et cetera. So we've added a couple people to the mix, so to speak. And then when I get down into 42, broker compensation. So much like we had in the RPA, existing written agreements upon execution of this agreement, tenant compensation to the tenant's broker. Again, we have a new form for that, right? So written agreement between the tenant and the broker, C.A.R. form TRBC. So that's going to be the tenant representation of the buyer's compensation, right? Or the LCA. And then finally, owner compensation to owner or tenant's broker. Owner agrees to pay compensation as specified in a separate written agreement between the owner and the broker, and that'll be the LL is the lease listing agreement, or the LCA. And then finally, under 42B, owner agreement to pay the tenant's broker. So in consideration for the tenant entering into this agreement, owner agrees to pay the tenant's broker. Think, buyer's broker. We're just replacing tenant with, from buyer. So fixed term lease, here's what it's going to look like, or a dollar amount, or some other figure, attached schedule, etc. For a month-to-month rental, this is how much. Payment is conditioned on the tenant taking possession of the premises or being prevented from doing so by the housing provider, which, believe it or not, that does happen. Payments made by the owner shall be credited against any obligation of the tenant to pay the tenant's broker pursuant to a separate written agreement. And then finally, again, remember, you have to have that written agreement. So that's going to be my TRBC or my LCA above. And then again, there's my third-party beneficiary language that the owner acknowledges that the tenant's broker is a TPB, as we say at law, to this agreement. Okay, everybody good? That should round that out. A couple little things in here under what we refer to as the broker box. Housing provider's broker and tenant's broker agree to accept the compensation as specified in 42 or in a separate agreement, and that should take care of that. Let me move this down a little bit. We're going to talk now. I'm going to get rid of some of these screens so it makes it easier for us to see what we're doing. RPA, RLM, and now we're going to talk about the buyer counteroffer form. Some good changes in this. And that's going to be down on paragraph number 3. This counteroffer is valid regardless of whether any previous offer or counteroffer expired by its terms. So in other words, when the buyer issues a counteroffer, this counteroffer is going to be good whether or not there was a previous offer counteroffer that has already expired. In other words, we can put this in anytime we want, okay? So we don't have to play that game with an expired offer and things like that. Late acceptance, if the date of the seller's acceptance is after expiration as specified above, seller's acceptance is only binding if the buyer agrees to the late acceptance by signing below, okay? So now we've made that official as well, because it used to be the seller would come back and sign the agreement after it expired. Now what do you have? They got people doing all kinds of crazy legal stuff and saying, well, this is intended to resuscitate that. You don't need that anymore. Here it is right here, folks. You don't need that anymore. So now what you have is, if it is late, if you miss that time, remember what that means when the seller misses the time period that the buyer has given them to sign the buyer's counteroffer, that just means that the seller does not have the ability to create a contract between themselves and the buyer. And so this is going to resuscitate that if the buyer signs it again. Everybody good? Here is my BRBC Lite. The PSRA form. I kind of like this form. Remember, please do not use this form if you are also using the buyer representation agreement. And so some minor changes in here. We've seen these already. We changed the essentially in B3 is the safety clause, otherwise known as the protection clause, that the Department of Real Estate actually asked you on the state exam when you got your state license. How many days is this good afterward? Remember that this agreement may not exceed 30 days, folks. So I would suggest to you that the B3 is probably also not going to be 30 days. So, or it could be 30, but I wouldn't suggest 120. Okay, that kind of thing. Everybody good? I think that should continuation of the right to compensation for broker-involved properties, and that's where the agent gives the buyer a list of properties prior to either cancellation or expiration of this form of properties that they expect to be compensated in. This is going to notify the buyer that the broker is expecting to be compensated for that. Okay. Broker's right to compensation pursuant to this paragraph shall only apply if, there it is, what I just said a second ago, prior to expiration of this agreement or any extension, broker delivers buyer written notice of those properties for which there was involvement, again, prior to expiration. So let's scroll down here. And here's that paragraph that I said that you, technically speaking, you'd only have to send this paragraph over to the escrow company, or in this case, yeah, to the escrow company, because this is, you only have to send this page. You don't have to send the entire agreement. Confirmation of compensation. Buyer confirms the compensation specified in 4B1 for broker services is, and that amount you would fill in, and if any, a dollar amount, whatever that would be, or a dollar amount instead of a percentage of sales price, or it could be specified in an attached broker compensation schedule. Okay, so everybody good with that? That should take us to the next level. So let's pull up the buyer confirmation of broker compensation. And again, this is just a restatement of the fact that the broker intends to be compensated for their work. And again, you know, some minor language in there, what that's actually going to be. And then we have our cancellation of buyer representation agreement. Whoa, heaven forbid, but you may just decide that, you know, it's just not going to work out, you know, that kind of thing. And so remember that the sword cuts both ways. So the buyer is committing to you, but you are also committing to the buyer. So you may be in a situation where you mutually agree to cancel. So what are the terms of that going to look like? Much like a termination of contract, notice only applies for the following: property, perhaps, or in C1, all properties. And then down here, it also says if it's for only the one property, then all the rest of them are still good. And then and et cetera, et cetera. So because the seller of the property identified has declined to pay all of, in other words, the seller has refused to pay the buyer's compensation, the buyer can say, I don't want to do the deal because I can't afford it, whatever. And now the broker has the ability to exit this part of it and essentially leave the buyer on their own. Of course, you would still want some protection. I'm not sure how widely used this form is going to be, but obviously you expect to be compensated for the work that you've done. So broker withdraws from representing the buyer for the property identified above. And then compensation due the broker. So during the continuation period, which is that safety clause, protection clause, and then finally in E2, only if both parties agree by signing in the mutual cancellation box below. Expenses occurred. You got to put the number in there if you expect to get anything. If you don't put anything in, they're not going to get it. Broker received a referral fee. It could very well be that you've worked out a referral fee with another agent that did get compensated, or if the buyer decided to go without a representation, the other broker can still compensate you. Okay, so there's your referral fee. That's an important point, right? So the buyer can move forward without representation, but you could still get an agreement with the seller's agent to receive a referral fee. Again, that referral fee goes to your broker. It doesn't go to you, or there's no compensation. One of those kinds of things. Okay, so important things to note. That is our cancellation of buyer representation agreement, our cancellation of agency confirmation. So once you put the agreement together, the RPA, for example, paragraph number 2B is confirmation of agency. And so that's what this form is intended to do. We're going to cancel that. The buyer's brokerage firm withdraws from representing the buyer in the negotiation for the property above, will not be the buyer's broker, et cetera, et cetera. Okay, so interesting new form for us. So that'll take a little getting used to for some of us. And then transfer of buyer representation agreements. So for example, you were with broker number 1 and you've moved to broker number 2. You would use this form. Let me see here. And this is a new form. So I'm going to, again, if you want copies of these forms, let me know. I'll send them to you. But again, notice they say draft across them. That doesn't mean it's chilly in here. That means that this is not to be used until the form goes hot in late December. Okay. All right. So transaction files, et cetera, et cetera. So again, this is the transfer if you've moved brokerages. So from the original brokerage firm to the new brokerage firm, and this is the form that you have to have signed. Otherwise, the agreement, because remember, the buyer representation agreement belongs to the broker. It doesn't belong to you personally. And it doesn't matter if you put your name in there or anything like that. People do that all the time. It's like, it's not going to matter. And then finally, the one form I think gets very little use, and I'm kind of surprised, and that is the summary of multiple offers. And so we're seeing less multiple offers now, but at the same time, I don't think I've ever received anybody sending me multiple offers that I use the form, and I probably should, because this is a pretty good form, right? Contingency period, so the seller can compare apples to apples. I think it's a good form. Frankly, we don't have quite that many multiple offers as we used to have. So everybody, that is kind of a summary of where we are with our forms. I just want to thank you very much for being here today. I don't want to waste your time. So thanks for joining us for our discussion and for the pre-release. If you want copies of the new revised forms, there's a link included in my newsletter. So if you are not getting my newsletter, well, and then you can also go to the YouTube website, and there's the YouTube website, at Burke Real Estate Consultants, Inc. Okay, and that will get you all of my videos. But remember to like and subscribe. Like because it makes me feel good. Subscribe because you'll get notified of new things. So all the people that have already subscribed to my YouTube videos are going to be notified that this one has been placed up there. Everybody good with that? Weekly email updates. You have to send a request to be subscribed because I do not put people in there unless they ask to be put in there. It is definitely opt-in. I want to thank you all for your time. I very much appreciate you, and I hope that your day is just as great as mine is. And if there's anything I can do for you, please let me know. Happy to help in any way that I can. Thank you so very much. Take care for now.